Good afternoon, everyone. Thank you very much for joining us today. We will be talking about family law. Is it all about money? Organized by Hugill and Denis Chang's chambers. Today, apart from all people with us today, we have more than 450 people signed up and joining us through Zoom. And we are accredited with 2 CPD points. At the end of the seminar, there will be 5 questions waiting for you to answer. You don't have to get it right, but you have to answer it before you can get your CPD points. Today, we have Jeremy Chan, who is a very experienced family practitioner, Raphael Wong, an associate of our firm Hugill, Tracy Ju, a relatively newcomer of the legal profession and a barrister at Denis Chang's chambers, and myself, Alfred, who is partner at Hugill. We're going to start the seminar with Jeremy Chan sharing with us something about money. So I'll pass the mic to him.
Thank you very much, Alfred. Today, I'll be talking about the concept of interim maintenance. And do we have the slides up? Yes. On the first slide. So I'll be splitting the topic into 3 different sections. One is interim maintenance in the context of divorce proceedings. So in probably the most common form of interim maintenance, where you have husband and wife, they're divorcing, and there might be a need for interim maintenance for the time being before a more long-term or final arrangement can be reached. Secondly, we'll be dealing with proceedings under the Guardianship of Minors Ordinance, typically parents of a child where the parents are unmarried, and therefore they cannot go through divorce proceedings. And thirdly, I'll also be covering interim maintenance in the context of CAP 481, the Inheritance Provision for Family and Dependents Ordinance, where after a financial provider has passed away, where in the context of a financial provider passing away, we find that the financial dependents are left in a situation where they require interim maintenance. And I will be highlighting some of the points which are special about each of these 3 applications, and possibly pitfalls, things to look out for, and things to watch out for in the context of these 3 types of applications. So we turn first to divorce proceedings. Divorce proceedings. Now, the law is a bit different, I say, depending on which aspect of interim maintenance you're looking at. In divorce proceedings, the section usually relied upon is Section 3 MPPO. This provides for the text, which I believe is displayed on the screen right now. This is the text of Section 3. Now, there are some points about Section 3 I would want to highlight. The first is that Section 3 is only engaged from the date of presentation of the petition. So you must first start your petition for divorce before you can rely upon Section 3. This is a statutory provision. There's no getting around it. The jurisdiction and power is not engaged until a petition is actually filed. That is not to say that you apply for interim maintenance immediately upon filing a petition. Typically, that application is made usually around the time of or after the Form Es are exchanged. I will come to later on the concept of urgency and when you might be applying for interim maintenance even before the Form E is filed. Secondly, Section 3, as a matter of statutory power, terminates upon the determination of the suit. The termination of the suit is a reference to the main suit, not suit as in every single aspect of the proceedings, but main suit as in the divorce. So upon decree absolute, the main suit has ended, and the power to grant maintenance under Section 3 ends. There is no getting around that. However, the case laws have developed to say that, well, in those situations, we can rely upon the post-decree absolute provisions to come up with something which is akin to interim maintenance, but it's usually referred to as maintenance pending trial, as opposed to maintenance pending suit. The trial there being a reference to the ancillary relief trial, as opposed to the main suit, which is for divorce. Strictly speaking, Section 3 only deals with the financial provisions between husband and wife, because it refers to either party to the marriage, and it talks about periodical payment for his or her maintenance, his or her being a party to the marriage. So strictly speaking, it might be said that Section 3 doesn't cover children, it only covers the wife. In reality, that distinction is hardly ever made. I'm not aware of any authorities actually drawing that distinction, possibly because it doesn't really make any material difference in real life. Of course, children are covered by other provisions, and those provisions are not subject to the same restrictions as Section 3. So they do not, for example, children maintenance provisions do not terminate upon decree absolute. So the power before and after DA is the same so far as children is concerned. Next, note that when we are talking about the MPPO, Cap 192, the definition of children or child of the family is quite distinctive and special in that child of the family includes any child who has been treated as a child of the family. So that could be a stepchild, it could be a not formally adopted relative who lives with you, it could even be a genetic stranger, someone who is not genetically related to the paying party. Okay, so long as a child has been treated, embraced by that family, that child will, for all intents and purposes in divorce proceedings, be treated as the same as a child who is actually genetically linked to the divorcing parents. Now, MPPO applications in the course of divorce, these are apt to cover spouses and children as well as curry legal cost provisions. The test is different and will come late in the latter parts of my section here to be talking about curry and legal cost provision, where a different test applies. So second topic, the Guardianship of Minors Ordinance, Cap 13. This is a different statutory provision and a different regime altogether. These are typically FCMP, miscellaneous proceedings in the family courts, as opposed to FCMCs, which are matrimonial causes. By contrast, GMO looks to parents and minors. These are the words used in the statute, parents and minors. The expression child of the family is not used, which means the GMO, in practical reality, what that means is GMO is primarily looking at, as a starting point, genetic linkage. You are a parent. You are either the father or the mother, or you're not the father, not the mother. Of course, there is also adoption, and when the law says parents, they mean legal parents. But generally, unless you're talking about adoption or something like that, it's generally looking at genetic linkage. And GMO does not, for example, give rise to a situation where because a person has financially taken care of a child for a while, even though he or she is not a parent, would suddenly take on a liability to carry on doing so. That is not how GMO is used. So that's important to bear in mind, is that we are talking here about parents. And the focus is on the minor's maintenance, what is necessary to maintain the minor. It is not talking about the caretaking parents, so typically often the mother. It is not financially providing for the mother. A mother in these situations, or a parent in these situations applying, typically would not be married and would not therefore have their own standalone claim under the GMO. That's important. There is a concept of carer's allowance, but case law authorities have shown us that carer's allowance is very limited in terms of quantum, and cases have established that carer's allowance cannot be used to replace income. So a mother cannot come along and say, I've given up a $200,000 a month paying job to take care of our child, therefore I want a carer's allowance of $200,000. That argument has been run before and failed. So the carer's allowance is not supposed to be a standalone independent claim. It is supposed to be really a stipend to assist the caretaking parents in providing for the child. Now, there are also a number of limitations on the Guardianship of Minors Ordinance. So because it might sometimes be thought, well, if I'm not going through a divorce, but we're married, well, why couldn't I apply for maintenance under the Guardianship of Minors Ordinance? There are restrictions, and we have displayed on the screen right now the relevant restrictions, which are where the parents are residing together. Guardianship of Minors Ordinance does contemplate that the parents are separating or have separated. They may have never lived together, but most of the time they will not be living together right now, because if the parents are still living together, then the order would not be enforceable until whilst they are still residing together, and such an order would cease to have effect after 3 months. So when you're looking at GMO applications, Cap 13 applications, you are usually looking at a situation where they have already separated, and of course that they are not married. Now there is also, this is something to look out for, an odd, I use the word odd because it is rather odd, there's a 3-month statutory limitation. On the face of the statute, without more, the statute appears to say that an interim order under GMO can only be made for 3 months, and that's it. Now, in practical reality, from the start of an originating summons until the substantive hearing, it's very rare. I don't think I've ever seen a case which has come on within 3 months. 3 months would hardly be enough time for you to file all your affidavits or your any valuation or running expense calculations. That sort of exercise, or even listening for the hearing itself, is likely to take you more than 3 months. So what the cases have told us, though, is that this 3-month statutory limitation cannot be taken too literally. Slide. Yes, authorities have clarified what this really means, and I've given here 2 cases. One is Madam Justice Chu, B.B. Chu, who says, there seems to be nothing to stop the court to make a further interim order upon cessation of the first one. So in effect, unless there's a change of circumstance, any reason to adjust up or down, the order really should be renewed. It should carry on being renewed. And in a further case, IDC SSA, a very famous case for its own reasons in a different context, but this is one of the aftermaths of IDC SSA, after the case had already gone to the Court of Appeal and back, and this is a judgment of His Honour Judge C.K. Chan. He says, I am aware that the wording may impose a period of 3 months for interim orders, but it said the accepted practice is to treat these orders as automatically extended. Now, that is an accepted practice. You may have opponents who are not cooperative, in which case it may well involve an application. It may well be an application that is shortly dealt with, but you cannot assume, for example, that the court will necessarily automatically extend every 3 months. And it may well be the case that you have to go back to court in the event of having an uncooperative opponent. Now, Curry, legal cost provision, is also available under the Guardianship of Minors Ordinance, just as it is available in divorce proceedings. There used to be in the past some debate about what section of the GMO the legal cost provision are really paid under. And again, in ICC SSA, one of the more recent decisions from 2019, His Honour Judge C.K. Chan has clarified that the relevant provision is section 13.3, which is interim maintenance, which is the same provision we've been talking about in today's seminar, interim maintenance under GMO. It is not section 10, which are the section containing final orders. Final orders are not subject to sort of adjustment within the near future. I mean, of course, orders are always adjustable and variable for children cases, but section 10 orders are looking at a mid to long-term future rather than in the immediate interim situation. Thirdly, we turn to the Inheritance Provision for Family Independence Ordinance, Cap 481. The points I would highlight that need to be looked out for in Cap 481 is, first of all, the statutory time limits. Cap 481 proceedings must be commenced within 6 months of probate being granted. The reference to probate, estate of the deceased is first taken out. That is a reference to the probate being granted. So you may well have caveats in place, and there may well be probate proceedings, but the moment the probate is sealed, the moment letters of administration, grants of probate is sealed, time starts running for the 6-month limitation. So you must start, if there are 481 proceedings, you must start them really as soon as possible, and in any event, not later than 6 months after grants of probate. Cap 481 can be relied upon on the statute by any financial dependent. Now, when I say any financial dependent, there are different categories and different criteria apply. For present purposes, we will mainly be talking about today spouses and children. For spouses, they will fall within subsection 3.1 Roman 1, and children fall within subsection Roman 5. There is also an others provision, which is in section 9, and we will also be dealing with that shortly. The others provision is typically relied upon by financial dependents who don't fall within any of the former 8 categories. In Hong Kong, most often mistresses and girlfriends, they would fall within, because they're not spouses, they're not children, they're not biologically linked, and they are mere financial dependents. They're not married, so the relationship arises only because there's a financial dependence. So those would fall within subsection 9. Now, one thing to look out for under Cap 481 is that there is a special meaning to spouse. it does not only include people who are lawfully married to each other, but also includes a person who in good faith entered into a void marriage with the deceased. So, for example, innocent bigamy. If a woman innocently married a man, not knowing that the man was already lawfully married to someone else, that would be innocent bigamy. In divorce proceedings, that would be taken into account, even though it would be an annulment or nullity proceedings rather than a divorce proceedings. That would still be taken into account, that she had innocently entered into a void marriage. For Cat 481 purposes, they fall within the definition of husband and wife. So for the purposes of this statute, it's the same as being married. Of course, you would have to prove your own good faith, that you didn't realize the marriage was void when you entered into it. But where that happens, that might be relied upon. Now, the expanded definition of child of the family is not included in Cap 481. So that's one of the differences between Cap 192, Cap 13, and Cap 481. Look out for the definition of child of the family or children. GMO and 481 are dealing with children, where we're dealing with children, are dealing with children in the legal sense, not child of the family, not someone who's treated as a child, although a financially dependent minor who is not a child of the deceased might fall within some other sections anyway. So for example, subsection 7, I've quoted there, any person not being a child of the deceased, because of course the child of the deceased would fall within subsection 5, who in the case of any marriage to which the deceased was a party was treated by the deceased as a child of the family may have a claim. Now, but the nature of that claim is different because of the words there at the end, immediately before his death. That is one of the special features about 481 that one must look out for. The words are quite obvious. It's immediately before death. You are financially dependent. That expression only applies to some of the subcategories, but not others. So, for example, it does not apply to spouses, but it does apply to subsection 9 for others financially dependent, and it does apply to subsection 7 for a child who has been treated as a family member. But it doesn't apply to children, okay, who are a legal child, a biological child. That would not apply. So that's one of the things to look out for. Next, and this requirement of being maintained immediately before death, as I've said, only applies to some categories. And another thing to look out for is that the definition of reasonable financial provision, this is an expression with two meanings. Okay? Reasonable financial provision is the expression used in respect of all the subsections, all the different categories of applicants. However, for some of the applicants, it means reasonable in all the circumstances of the case. The important words are whether or not required for maintenance. A fortiori, what that means is it can be more than maintenance. So for example, maintenance is referring to recurring expenses. It doesn't refer to capital expenditure. It doesn't refer to investments. It doesn't refer to substantial donations. Whereas under the first limb, which applies to, for example, spouses or widows and widowers, reasonable in the circumstances could go above maintenance. And we will come to deal with the spouse category or the widow or widower category specifically. However, for all other claimants, if you do not fall within the first sort of definition of reasonable financial provision, for all other applicants, the definition of reasonable financial provision is limited to maintenance. Maintenance, so in the case of an adult, would be akin to a needs type claim. Needs taking into account, of course, the applicant's own resources, own earning capacity, own income. And in the case of a child, would be maintenance in the usual sense for a child. Now, in the case of a widow or widower, so where you are married and the spouse passes away, there is also a special provision to look out for, Section 5, subsection 2, which establishes something called the quasi-divorce standard, where one of the questions the court must, as a mandatory provision, the court must ask itself is, what would have happened if instead of passing away, there had been a divorce? The rationale, one supposes, might be the result of a marriage ending should be approximately the same, no matter whether it ended by death or by divorce. There are two different ways of ending a marriage, but whichever way it ends, it should not, for the other party, for the receiving party, it should not be a financially dramatically different affair. It also means that you cannot, in general, write your husband or wife out of the will. That is, in general, not a good idea for its own obvious reasons. But also, if you went to a lawyer, you would probably be advised not to do that because they would be asking for litigation. Cap 481, Section 5.2 could be triggered, and you might find your relatives, your widow, widower, and children in court fighting over it. For interim maintenance scenarios, Section 7 also has a special provision not found in for example, GMO or divorce proceedings, which is immediate need of financial assistance. That is an additional hurdle that exists in Cap 481, but does not exist in, for example, GMO or divorce proceedings. So that's another thing to look out for. And I've also got some takeaway points, summaries of overall of interim maintenance applications. The important point overall, and this applies to all maintenance applications, whether under divorce proceedings, GMO, or Cap 481, the criteria is always reasonableness. The predominant focus is on the financial status quo. So in general, what the standard had been, either before the deceased passed away or before the marriage broke down. And in every maintenance pending suit case, there should be a specific maintenance pending suit budget. Excludes capital or long-term expenditure, and excludes, for example, investments or other large purchases. Children's expenses in these cases are usually a mixture of undertakings and a monthly dollar sum. The undertakings tend to be for things which are variable or can very easily be dealt with by way of direct payments, direct debits, school fees, boarding fees, rent, things like that, or even a mobile phone contract, things where you can easily arrange for the paying party to pay directly. There should be a reasonable amount of evidence when one is going to court about outgoings and expenses. The assessment is always broad brush and can be subject to adjustment later on. Later on meaning between now and the final trial, or if there are any change in circumstances in between. The financial means of the paying party is always important. Now, one of the questions one should always ask oneself in interim maintenance cases is, has there been full and frank disclosure? Because where you find, for example, if we were on the side applying for interim maintenance and we find that the other side has not been full and frank in the financial disclosure, then it will be more difficult for them to be heard to be saying, I can't afford to pay X dollars a month because I don't have sufficient income, I don't have sufficient assets. Well, have you first given full and frank disclosure? Another thing to bear in mind is His Honor Judge Bruno Chan, as he then was in DX and LN, said, in most cases, and this is really more a reflection of experience and reality than any particular points of law, in most cases, when people separate, when a couple separates, they will be maintaining two different households, and usually that will cost more rather than less than before. 1 + 1 is greater than 2, so to speak. There are, for example, 2 sets of legal fees, which previously did not exist. They are now at loggerheads and fighting with each other, paying 2 teams of lawyers. That was the expense that the family never had before. So that sort of thing has to be taken into account. Is the family so wealthy and earns or has so much asset that even after paying for all the lawyers, there's still enough money to maintain the same standard of living as they enjoyed during the marriage? That could be the case in some cases, but it's probably not the case in most families. Now, in Cornick, and this is a case where, for example, if the payor's resources had decreased dramatically, it may be possible to argue for downwards variation. Now, this could occur, for example, where a certain budget had been set, and we find between now and the trial that, for example, we have come across cases last year in 2020 where, because of COVID, some people have had their pay cuts, or they've actually lost their job. In those situations, you might apply for interim maintenance to be suspended or varied downwards because of a reduction in income. Next, we'll deal with the application process and cases of urgency, including legal cost provision. As with most applications, an interim maintenance application goes through your normal stages of having a call over for directions, filing of evidence, and then having a substantive argument. And that process, as we know from experience, takes months. So one question we should always ask ourselves is, are there grounds for, or is there a reason to be applying for interim maintenance? So an immediate order at the call over hearing. If you're going to do that, then you better have done your homework beforehand and prepared for it. For example, to have filed a substantive skeleton, to make sure that your disclosure is actually of sufficient standard, to make sure that to anticipate what the other side's arguments might be in response to an application for interim immediate maintenance, because of course the spouse and children may be in such dire financial circumstances that they can't even make it until next month. What we sometimes find is one of the spouses may have a little bit of savings, but it's not really enough, not just to get past a few months, but not really enough even to pay the lawyers to argue the MPS application, because the MPS application, of course, has its own sets of evidence and affidavit, and there will be a substantive hearing if the other side doesn't agree. That itself is a costly process, and a spouse may not, or the financial dependent may not even have enough assets to be able to fund that first hearing. So that leads us to Curry legal cost provision, where I've dealt with some of the overarching points. The overarching inquiry is always whether or not you can demonstrate the four factors: assets, ability to borrow, ability to charge on the outcome, and legal aid. Legal aid in particular is a touchy topic because a lot of people don't qualify for legal aid because of the size of the family pot. But even where you do qualify for legal aid or could qualify for legal aid, there are cases saying that where the family itself has enough assets, even if one of the spouses could qualify for legal aid, for example, because the husband holds everything and the wife doesn't have anything in her hands, it may not be fair to ask that the other side apply for legal aid as opposed to applying for Curry legal cost provision. After all, legal aid will run into a different regime altogether. You're subject to far more stringent conditions. You're restricted as to the lawyers you might be allowed to appoint. You're restricted on how many numbers might feature in your team. And you might find that a lot of applications are scrutinized by legal aid. Whereas the court itself, the family court, has every interest in keeping active judicial involvement, as it is called, which is in line with the modern approach. So that's something to bear in mind. Legal cost provisions are normally provided for in stages. Now, usually at the first stage, where an application is made early on, the normal method is to provide for up to FDR. Now, that's a logical step because at the FDR, the case might actually completely settle, in which case there's no need for any more legal costs to be incurred. Where the case does not settle and FDR fails, the question of legal cost provision can be revisited, and at that stage, it would typically be usual to provide for legal cost provision up to the trial, possibly up to the trial, but not including the trial, because again, the case might settle between then and the trial. And where one is asking for a Curry legal cost provision, there should be a back of the envelope type estimates of fees. This is similar to other civil cases where you ask for security for costs, but bear in mind the crucial distinction, which is security for cost cases are normally awarded or calculated on a party-party taxation basis. The reason being you are securing the opponent's cost claim in the event he or she or they succeed. Whereas in a Curry legal cost provision situation, you're dealing with the party's own legal fees. So there is no logic to taxing it down on a party-and-party basis. That party has to pay his or own lawyers, in effect, on a solicitor-owned client basis, rather than a party-and-party basis. Now, is this? Yes, thank you. We're turning over to Raphael now for the next section.
Thanks, Jeremy. So what I'm going to do is just a quick summary of what Jeremy has said, and then we'll go to the juicy bit as to how the law is being applied. Okay. Now, we learned that the application of interim maintenance, or MPS, is not only available to divorced couples, but also parents with children and also dependent that is suing the estates. Now, the purpose of this type of application is to allow the applicants to maintain as much as possible the status quo pending the determination. I said here as much as possible because, as Jeremy has just mentioned, very unlikely if you are not one of those big money cases. If the parties are separated, there will be two sets of costs, whether it's living or legal cost. And therefore, it's very likely that the standard will have to be adjusted after the separation. Well, the tests for these kind of applications are quite standard. It's determined on a broad brush approach, and we look at the needs of the applicants and also the respondent's ability to pay. If there are any over or underpayment, it will be adjusted in the final order. Now, there's a slight distinction here between typical divorce cases and Cap 481 proceedings, and when it comes to adjustments. In divorce proceedings, it's usually between the husband and wife, which is arguing over the matrimonial part. But in Cap 481 cases, we are dealing with the estate, and there are potentially more than one beneficiaries. So what usually happens is that when making the interim maintenance order, the judge would impose an additional condition whereby if the judge later on rules that the applicant should not receive that money, the applicant has to repay that to the estate. So there might be a slight difference between divorce cases and Cap 481 cases. And also we learned that these applications can also include legal cost provisions, and sometimes these are considered as reasonable needs. Okay, so what are the common issues that practitioners may face when dealing with this type of applications? We were saying that the reasonable needs is usually reference to the standard of living. If you have a very typical case where the wife is a housewife and the husband is the sole breadwinner, and after a certain year of marriage, they establish a standard of living, then what I quoted there, this is a case, this is judgment of Deputy District Judge George Hong as he then was. And it's pretty much to summarize the typical scenario for MPS applications. You see, I highlighted the words where we have the ability of the payer, and also the established pattern of payment. What established pattern of payment here, it seems to justify what the standard would be by the parties if the wife has always been receiving the same amount of money, and also if the husband has always been paying the same amount of money, then it goes to show the standard and also the ability of the payer to make the payments. So, this quote also says, to put it another way, it is akin to penalize the wife for filing a divorce. It also shows the purpose of the MPS application or interim maintenance application. But it's not always the case that there is a standard of living. For example, the first bullet point that says, what if there's a short marriage and there's an infant? Now, with an infant, we don't really have a standard per se. We don't know what school the infant will go to, or the diapers that they have to change, or the baby powder, etc. So in these type of cases, then the argument of what is reasonable is become much more tricky. And in these type of cases, the court will usually look at immediate needs rather than the established standard of living. The second bullet point I have is not everyone here keeps receipts. Now, Jeremy's talked about that there has to be some sort of evidence when we are making the applications. But sometimes, or actually most of the time, we do not keep receipts. This is more prominent to applicants who use cash a lot. Might not be so applicable to people nowadays, as we tend to have e-wallets or we spend with credit cards. But if it is very cash-based, all you can see from bank statements would be there's some funds coming into the bank account, and then we withdraw the bank account, and that's it. There will be no trace of any payment whatsoever. So this will impose a further difficulties when the practitioner is trying to establish the standard of living. Next, I want to talk about the ability to pay. Here it says the loss of job and earning capacity. Now, what sometimes will happen is that you have a husband, after the wife filed for divorce, he decided to quit his job. If that's the case, then the court will not rule based on his current income, but rather his earning capacity. And so it will bypass the issue that he will have no earnings. But sometimes if the husband or the payee does not have a job but runs a business, the trouble with that is if that business is heavily cash-based, then on paper, the business might be losing money. So what we have to do is that we'll have to look again at the standard of living in the past. And if there's a track record that the business is losing money, but at the same time manage to support the family, then we can show that the husband actually has the ability to pay. Now, there's a need to use capital. Well, as Jeremy said, if there is a very dire situation and there's completely no income whatsoever, then we have cases where the judge will have no choice but to still make the order, and then for the family to sell some of their assets to pay for the expenses. How COVID affects the application? Well, COVID certainly affects both the standard of living and the ability to pay. But what I wanted to add is that very typical, you see nowadays judgment, probably Jeremy can chip in, is that judges are very ready to say no to holiday expenses because no one is traveling due to COVID. But I last checked yesterday, in fact, it's a case that Jeremy is involved in, which is quoted here. And in that particular case, Jeremy was able to argue that staycation is a reasonable need. And I'm sure Jeremy has a lot of things to say about that. But I wanted to say about the second point is that the COVID not only affects the loss of job, it might goes beyond and affects the earning capacity. For example, if the husband, say, is a pilot and the COVID destroyed the whole traveling industry, he might lose his job, and he might further argue that not only that he lost his job, but he also lost the earning capacity solely because he cannot find another job or find another job with the same level of pay. So Jeremy, you want to talk about the staycation point?
Yeah, certainly the real life experience has been that during 2020, judges have mostly been slashing holiday expenses. But of course, holiday expenses have been partially replaced by other things. Some other expenses have increased during COVID. Of course, there is staycation, that is part of it. But there's also things like tutors. A lot of parents, especially those who can afford it, have been dissatisfied with Zoom classes. And I think, look, if it's all just Zoom classes, some parents think that's not very different from watching an online lecture. So they want some real-life interaction. They want someone to actually assist the child along. And they might hire tutors. Now, that's actually quite expensive in Hong Kong, especially if you have a tutor for each different subject and someone comes in several times a week. And those expenses very quickly add up. So one has to bear in mind that COVID, of course, has affected earnings. In fact, both ways. Some people have suffered during COVID, but others have thrived during for example, Amazon or the logistics business have thrived during COVID. And on the expense side, some expenses like holiday expenses are gone, but it might be partially replaced by or even exceeded by some of the COVID-related expenses that have become necessary.
Thank you. So the last bullet point I had on this slide is the law only allows for periodical payment. But the implication is that the court will not reinstate credit cards that has been canceled for the spouse. That is beyond the jurisdiction power of the court. The same applies to membership. And I said here that what about those one-time purchase for certain necessary expenses? For example, there's an urgent need to replace a bed for the child, say. There's a one-time purchase, but it's not a periodical payment and it's not a recurring expenses. So what the judges will usually do if there is indeed an urgency, they will backdate the periodical payment starting from the date of petition instead of the date of the application or the determination of the application, thereby giving a larger sum of initial capital to the applicant, whereby the applicants can use it to discharge all these one-time purchases. Unfortunately, to my understanding, the court will not reinstate credit cards, and if the applicant has no means to apply for credit cards of his or her own, that might be problematic. But for memberships, for some memberships, to my understanding, you just have to pay, and that can be part of your application. But for memberships such as Jockey Club, which my understanding is that once that has been terminated because of the divorce, you cannot apply for it. So, and that is something that the interim maintenance application cannot assist you. Okay, so we talked about the legal cost provision, but how in practice it is being assessed. Now, this is a Court of Appeal case, and I won't trouble you to read all this, but basically, to summarize these two paragraphs, is a guesswork. Okay, for legal cost provision is forward-looking. We have to project going forward the amount of legal cost. But what is the takeaway point from this judgment is that it would be counterproductive to require a detailed breakdown for future causes. Even for big money cases, even though it warrants greater details, but breakdown and details commonly found in the statement of costs for summary assessment should be sufficient. So in short, it is a guessing game for the petitioner and also for the judge, and is highly dependent on the facts of each case and the level of legal representative by the parties and the expected applications to be taken out. Enforcement, well, getting the order, it's only half of the job done. Getting the money, it's what we want to achieve. And if the proceedings last very long, which is not unheard of, then enforcement can be a very real issue, especially if you are asking for payment from an applicant that doesn't work in Hong Kong, has no assets or income in Hong Kong, then enforcement can be very tricky. But the usual enforcement rights or power is available to the applicants, such as in other typical civil jurisdiction. But what we have to bear in mind is that each application has its own legal cost. Be it you are applying for the interim maintenance or after you get the order to take out enforcement actions, these are all legal costs involved. And we always have to bear in mind the costs involved and whether the cost can be can be recovered. But it's interesting to note that usually legal costs follow the events. If you manage to succeed in your application, then you usually get your cost for that application. But for interim maintenance applications, we have seen cases where the judge simply says, oh, I consider that the applicant has no choice but to take out the application. But even though he or she may not succeed in the application, I still decided to order cost for her or him, solely because that the applicant has no choice but to take out the application. That's one thing that we have to bear in mind. And lastly, I just want to touch up on legal aid. Obviously, if you're legally aided, you will not be asking for legal cost provision. But then under Section 18A of the Legal Aid Ordinance, maintenance applications or any sums that you're able to recover are subject to legal aid first charge. And at the moment, the amount is $9,100. That is, if you manage to ask for payment for the spouse over this sum, it will be paid to the Director of Legal Aid. It's also important to note that this restriction only applies to maintenance to spouse, not to children. That is, if we are making an application, we will specify the amount we're seeking for the spouse and also a specified sum for the children. Therefore, when the judge makes the order, he will specify that, oh, certain sum is for the spouse and the other sum is for the children. And therefore, the legal aid first charge will not apply to children maintenance. Okay, that's it for me, and I hope you find it interesting.
I think we have some time for some question, but before that, actually, I do have one. A lot of time we come across dependent in a relationship. Sometimes it's the wife, sometimes it's the husband. They usually stay home and mind the children, therefore they don't have independent income. And they come across cases that when the marriage is breaking down, they know that, for example, the husband is cheating. They want to get away from the relationship, but a lot of times they cannot afford to, they don't know what to do, basically. What would be the first thing that you would advise them to do? They want to get out of the relationship, but they don't know what to do.
I think the first thing they should do is see a lawyer. Of course.
And then the lawyer will be telling them that, oh, it costs so much to divorce.
Now, I think as a family practitioner, one of the first things we need to do is to ascertain what the client wants to do with his or her life. I mean, one of the things I often emphasize is we are your lawyers, we can assist you on points of law, but we are not relationship counselors, and we certainly are not guiding your life. So litigation is one thing, financial consideration is one thing, but do not let that ruin or govern your entire life. You have to mix your own life decisions into it as well. But if you've made up your mind, you want to leave the relationship, or you want to divorce, or leave with a child, whatever it is, then you can take the appropriate steps, make it happen. And for example, in divorce cases, once a petition is filed, you can start asking for maintenance. In GMO cases, once you file the originating summons, you can start asking for interim maintenance. It may be difficult in getting past that first stage because you do need some amount of legal funding to start the proceedings before you can start asking for and making applications. If the opponent is reasonable, you can write to the other side first and see whether some agreeable arrangement can be made. Yeah.
But a lot of time, people do find this kind of complicated legal proceedings very stressful. And especially when they're going to a family court, they have to attend in person, and they're very scared about going into court because they've never been to court in their life. What is it that we can do to help them navigating through these difficulties and addressing to their fears?
Well, as Jeremy said, we are not counselors, but we will instruct Jeremy for the job.
I think there's one thing that what we come across as legal practitioners always face is that clients do not know what to do. And it seems like the legal proceedings have always been prolonged for many, many months. For example, the first appointment always happened 3 or 4 months after the petition is being issued. And there are, a lot of time we come across the questions, what is going to happen if my husband stopped paying me for the maintenance? Jeremy, you have pointed out that we can go to court. But how long will it take for something like that to be heard and for a court to make an order?
Well, I would say it depends on the urgency of the case. I mean, in sort of typical or usual scenarios, yes, you start the petition, the first appointment is hopefully not too many months away, and usually by the time of the first appointment, you will be exchanging or have already exchanged Form Es, so you should be in a position to be making maintenance applications. If there's something extremely urgent, yes, we have come across situations where at the same time as issuing the petition or at the same time as issuing the originating summons in the GMO case, we immediately ask for maintenance and legal cost provision. As I've said, the typical, the sort of epitomous example of that would be where the person applying, where the a mother or wife or what have you, the receiving party, the applicant, the petitioner, finds that he or she does not even have enough money to pay lawyers to get to the next hearing. Well, in those situations, the court, of course, would be far more sympathetic. Urgency is a matter of case by case. Urgent can mean we must have the hearing tomorrow, or it can mean we can have the hearing within a few weeks, or it can mean we can have the hearing next month. Of course, the usual state of the court diary is that hearings are usually a few months away. But in cases of urgency, you can always get an urgent hearing.
For those who do not know what is a Form E, it's a financial statement. It's around 20 pages for the parties to fill in, setting out their assets, liability, income, and expenditures. And if you have any particular order to ask, you are also asked in the Form E so that the court can consider and the parties can argue it in court. Yeah. Do we have any questions from the floor? We have two questions.
So the first one is, if a divorce agreement is silent as to what happens to maintenance provisions in the event of a death, what is the default position?
When you say divorce agreement, I presume it's a divorce settlement, which would be finalized in the form of a consent order. So where you have an agreement on what to do upon divorce, and it's turned eventually into a consent order, and you're assuming for the moment that it's silent as to what happens to maintenance upon death. Now, this is where Cap 481 comes into play. Because under Cap 481, there are specific provisions, which off the top of my head, I don't remember which one, but it's very easy to find. There is a specific provision that says, in the event of divorce, if the court orders it, you can, in the divorce settlement, cut off future claims for under Cap 481. And in fact, that's a very usual provision to have in settlements, in divorce settlements, in the consent summons and the consent order. There is usually a clause very near the beginning in one of the undertakings where the parties agree that this consent order is in full and final assessment of all claims under all ordinances. And Cap 481 is typically one of the ordinances listed in there. So it would be unusual for a divorce agreement, a consent summons, a consent order. It would be quite unusual for it not to provide for Cap 481 rights being terminated, and you can't make a Cap 481 claim after death. But where, for some reason, it doesn't contain that, then a wife could actually go to court and say, I was a dependent, I was his wife, and at the moment he passed away, I was still receiving maintenance. Now I'm not receiving any more maintenance because he passed away, so I would like it replaced by a maintenance claim under Cap 481. That could be the results, but it's very unusual in real life because if a lawyer is involved, we would always put in a provision saying that 481 claims are not allowed.
Maybe I read the question differently. I thought, maybe I read the question differently. I thought it's asking for the default position of maintenance provision in the event of death. The provision says that it's up to the joint life of the parties,
yes,
right?
Yes.
So I think this is what it is talking about.
Okay. Well, yes, the statute provision for maintenance is that it must end upon the death of the party. So there is actually no power to continue maintenance after death under the divorce jurisdiction, which is why we were talking about Cap 481. But the death is not the only situation where it ends. Remarriage also ends maintenance. So again, it's one of those things which the court has no power over. If the receiving party chooses to remarry, then maintenance must end. Of course, in this day and age, you might just cohabit with someone and not marry them, which is why a lot of the times settlements which involve an element of maintenance on an ongoing period of payment very typically contain a clause saying, in the event of death, remarriage, or cohabitation for more than 6 months, your maintenance ends. So we know that that's what people do, and it's usually provided for in settlement agreements.
If the agreement itself is silent on this point, my past experience is that the judge will refuse to make the order. The judge will, when he was screening the agreements, he would have to add the condition or the stop period of the maintenance revision. So even though the agreement itself is silent, at the end of the order, then there will be the specification as to when the payment will stop.
We have another question. This is a sort of procedural one, which is how a divorce petition and application can be served and enforced if the respondent is domiciled and is residing out of Hong Kong jurisdiction, i.e. PRC. Now, of course, Hong Kong is part of the PRC, but the mainland is a different jurisdiction. The answer to that question in respect to the mainland is that right now, at this very moment in time, Hong Kong family court orders are not recognized in the mainland. So, in fact, you can walk into the mainland with any Hong Kong family court order, whether it's for custody, care and control, access, maintenance, periodical payment, lump sum. None of those are enforceable. We have a bill going through LegCo at the moment dealing with reciprocal enforcement between Hong Kong and the mainland in family court cases. That's what has already been the subject matter of an agreement between the Department of Justice and the mainland counterparts. It hasn't yet been turned into law. And the agreement between Hong Kong and the mainland is that when Hong Kong has its own law ready, then the mainland will implement their version of reciprocal enforcement by way of judicial interpretation. Judicial interpretation, as you might know, is a much quicker process. It's not a legislative process, and it can happen very, very quickly. I presume that our mainland counterparts actually already have their judicial interpretation ready, but they're waiting for our law. So once our laws are ready, we'll be reciprocally enforceable, and questions of enforcement on the mainland will become far easier. The reverse, however, has always been less problematic. A mainland divorce order is automatically recognized in Hong Kong if you fulfill the criteria under Part 9, and a mainland financial order was always enforceable as a common law action on a foreign judgment, because the mainland being a foreign jurisdiction. So they've always been enforceable under common law anyway. So the reciprocal enforcement is actually far more significant for Hong Kong orders being enforced in the mainland, although it will also assist, but it's never been critical to a mainland order being enforced in Hong Kong. And for children orders, it's quite typical for the Hong Kong court to say, well, look, there's a foreign judgment on it. There's a foreign judgment dealing with children, and we should give sufficient weight and respect to that decision.
Sorry, Jeremy, that means that if the husband is in China, it's better to petition for divorce in China so that the order can be enforced in China.
Yeah, that is often a question we discuss before or even after a petition. And that consideration, I think, doesn't only turn on enforcement and enforceability, but also the nature of the case. Because the legal system, of course, we have two very different legal systems, and there are a number of critical distinctions between them. These are not necessarily advantages or disadvantages. They are differences which, depending on which side you stand and how your family is structured, make a difference. For example, the burden of proof is different. In Hong Kong, we have the concept of full and frank disclosure. A lot of continental systems, mainland included, does not have a system of full and frank disclosure where you have to disclose all your finances within a certain window or framework of time. On the mainland, as we understand from practice, I'm not a mainland lawyer, but from practice, I understand the situation to be that in the mainland, if you allege that your spouse is hiding assets, in general, you have to come up with the evidence to prove that, which from a Hong Kong perspective, or from a Hong Kong practitioner's perspective, would make life very difficult. I would not quite know how to do that. But of course, if you're standing on the other side where you don't want to disclose your assets, then you might actually prefer that system. So it depends really on which side you're on, how the case is structured. They also, in the mainland, for example, they have a much more concrete version of 夫妻共同財產 or matrimonial assets. Is a much more concrete, hard definition, and 50-50 applies far more rigidly than in Hong Kong. In Hong Kong, it's a starting point, and a lot of cases don't necessarily end up 50-50, depending on a large number of factors, which I think Tracy will be going into.
Before Tracy comes to the part, there are also two questions. I don't know if you have the time. Okay, we'll wait for the end. Okay, so there will be more questions for you, Jeremy, later. But first, we'll have Tracy doing her part.
So thank you, Jeremy and Raphael, for discussing maintenance pending suit and any interim applications. For mine and Alfred's part coming up, we're going to discuss primarily what happens after the final orders for ancillary relief have been determined for the spouse and the children. So I will go through some of the big principles and some of the cases, and then later on Alfred will guide us through a case analysis and possibly discuss how that can be applied in real life to give all of you a better understanding. So when can these final orders be made? Section 4 of the MPPO governs financial provisions for the spouse, and they can be made upon granting the decree nisi or on or before or after the decree absolute. However, under Section 25, the order will only take place after the decree absolute is made. It's a little bit different for children, which is governed under Section 5. That can be made before or after granting of the decree nisi or the absolutes. So basically, anytime the application is made. Section 25 will not apply to children. And under Section 10(2) of the Guardians Minorship Ordinance, for children with unmarried parents, similar provisions can be found in that section. So the type of orders that the court can award is listed there. So for financial provisions, it can come in the form of periodical payments, secured periodical payments, and lump sum orders. And some other orders could be, for example, transfer of property or the sale of the property, usually the matrimonial property. I won't go into too much detail in terms of the orders for transfer and sale of the property, but for periodical payments, the duration of the order for the spouses, as Jeremy and Raphael just answered in the previous Q&A section, it's normally until remarriage of the party or the death of the party, whichever is earlier. Now, provisions may also provide that cohabitation will also cease the periodical payments. But if the paying party predeceases the claimant, then the husband or the spouse that has been receiving the payment can apply under Cap 481 for a claim against the person's estate. In terms of the child, normally it would begin after the application is made, but it will cease at the age of 18. But Section 10 of the MPPO states that provisions for children can extend if they continue to be educated after the age of 18. So for example, if they intend to go to university or undergo training for a profession, such as training to become a lawyer or a doctor or any sort of other trade, these financial provisions may be extended to until the end of possibly their education, which may go on to until after the age of 18. And then, of course, the court will also take into any special circumstances of the child, which could justify extending the provisions for the children. So clean break is a term that we do hear quite often in terms of maintenance and ancillary relief. A clean break could occur if the court decides that it's not suitable to have periodical payments or secured periodical payments. Usually it's for cases where there is some excess of surplus and that the parties will be able to afford a clean break and provide a lump sum to the other spouse. The benefit for a clean break is that parties will be able to deal with the marriage and end all financial payments as soon as the end of the divorce and be able to move on with the rest of their lives without being burdened by their past marriage. The downside to that is that it will prevent any further variations of the maintenance in the future. So once the clean break is made, then financially, then the parties are done. The clean break provision will only apply for the spouses. You can't ask for a clean break for a child because, of course, as a parent, you can't cut off, just pay a lump sum and then be done with all the obligations as a parent. So it can be applicable for the spouse, but generally not to the child. So where there's a clean break that the court will consider, an option for them to calculate how much the lump sum should be can be dealt with by the Duxbury calculation. This is derived from the case Duxbury versus Duxbury in 1987. And basically the calculation is taking into consideration the amount of the lump sum, and if you invest that lump sum to produce income to meet the recipient's needs for the rest of her life, how much that lump sum would be. So it would take into account things such as life expectancy, rate of inflation, growth of capital, taxes, or return on investment. When they say that the amount will be up until the person's life, the calculation is basically up until, for example, if you live until 80, then it is expected by when you reach 80, the last day of your life, then you would have nothing left behind. This is normally calculated by accountants, so lawyers don't have to be burdened by these calculations. But in White versus White, it did make a comment that the court did make a comment that this approach is not required by statute, so it's not a rule, it's just a tool that the parties can adopt. So we have discussed some of the major points regarding financial provisions, such as how it can be made and the order, the time that the order can take effect. When the courts actually go into discussing how much assets to how the assets will be distributed, they will look for spouses into the famous Section 7 factors. So Section 7.1 of the MPPO, it lists 7 factors that the court will have to consider. Some of the factors are pretty straightforward. So for example, it would include the earning capacity of the parties, income, financial resources, or any foreseeable financial resources. They will also take into consideration the needs and obligations, the standard of living, duration and age of the party and the marriage, as well as any physical or mental disability, contributions, or anything that the party may lose benefit to because of dissolution of marriage or any loss of chances of them requiring because they got married. I won't go into detail in each of the factors, as I mentioned, because some are quite straightforward. But for some of the elements, I may consider and discuss a little bit more. As you can see that the 7 factors are listed in the ordinance, but the court does not view a certain aspect as more important than the other. So there's no hierarchy saying that needs is more important than the duration of marriage. In terms of the weight that the court puts into each factor, that's discretionary, and it will depend on each case individually. So when we talk about the first factor, which is the income, earning capacity, property, and other financial resources the parties may have or may come across in the foreseeable future, the assets are determined at the date of the trial. And also these assets, financial resources may include things such as the matrimonial property, any other property that the couple may have purchased over during the course of their marriage, shares, bonds, their cars and boats, and these are all the things that you can assume that will be considered as part of the matrimonial pot. And foreseeable future financial resources may generally include annual bonuses, but inheritance generally is not included in this section because wills can change over time, and as well as estates can diminish over time. So in general, it would just look at the foreseeable future financial resources that they will have for sure. And the financial needs and obligations are also quite straightforward. It may depend such as the debt, or if a spouse is providing for his or her parents. So if they give a certain amount to their parents each month, that will be included, and any other foreseeable obligations. Now, in some cases, the resources will be limited. And in those cases, needs will be determined a little bit more strictly and will refer to primarily the daily necessities and accommodations. For parties who are a bit more wealthy, needs would generally be interpreted a little bit more broadly to cover other type of reasonable requirements. In terms of standard of living, important part that Jeremy also mentioned in his part is that the court understands that if a party was enjoying a high standard of living during their marriage, it should not be taken for granted that just because it's a factor for consideration that the standard of living will be duplicated and replicated into 2 households, because it's extremely expensive and not all marriages will be able to afford the same standard of living for 2 separate households after the divorce. However, it is dependent on the party's ability to pay, and the court will take that into consideration, but it's not something that parties should take for granted upon divorce. The age and the duration of the marriage will also be important. The age, because depending on how old you are, it would affect the earning capacity of the couple. So for example, if you're getting a divorce at the age of 65, obviously your earning capacity would be different than someone who's getting a divorce at the age of 25. The duration is important as well, because as the marriage goes longer, so for example, for a marriage that has gone on for 20 or 30 years, the line between what belongs to one party or the other spouse, it's going to be a bit blurred compared to a shorter marriage where you can easily draw the line as to when the marriage had taken place and what assets belong to who. In Miller versus Miller and McFarland, in that case, the court did say that because shorter marriages, there will generally be less for the parties to call up on the breakdown of a shorter marriage. And the sharing principle would definitely apply to both long and short marriages, but in LKW versus DD, the court made the comment that when the short marriage comes to an end, fairness may dictate that one party will exit the relationship with less than half of the total assets. So even though it will be considered and sharing principle will apply, in practice, if the marriage is shorter, it's less likely that it will be applied. Contributions will also be important. Nowadays, it's important to consider non-financial contributions. So for example, a housewife that has stayed at home and cared for the family, took care of the home, or supported the husband, her non-financial contributions will be taken into consideration. And of course, the financial contributions by the husband will also be considered. In WLK versus TMC, in that case, the wife had to comply with the husband's wishes, and she accompanied him to frequent business travels and kept his mother-in-law and sister-in-law company. And in that case, the court awarded her an extra 2% of total assets on top of her needs-based awards because of these contributions. And when we talk about the last factor, the Section 7.1g, it talks about what the party may have lost as a result of the dissolution of the marriage or any loss of chance of acquiring because of the marriage. So some examples would be, for example, a leading lawyer in London, but after she got married, she decided to stay at home and care for the family. She was deprived of her own income. So that's an example where this consideration would apply. Another example is in WLK versus TMC. The wife aspired to be a concert pianist, but she gave up that ambition in contemplation of marriage, and that was considered that for a loss of chance of becoming a successful concert pianist. Now we move on to the financial provisions for the children. What's important to note that just because the parties are divorced, the obligations as a parent does not end there. And in general, both parties, both parents will have the obligation to maintain and continue to care for their child in their capacity as a parent. Obviously, it would depend on the parties' abilities to pay as to how much to contribute, but it's, as I mentioned, the clean break would not be appropriate for children because the parents' obligations do not end upon divorce. So Section 7.2 of the MPPO, you will see 5 factors that the court will consider in making financial provisions for the children. You will note that most of these would overlap the Section 7.1 factors for the spouses. The difference, for example, would be education, or standard of education would be important and considered, and as well the income and earning capacity for the child. It's not necessarily only whether the child has any money or whether they're working or not. This will be considered, for example, if there's a trust to their benefit, or if there's a savings account that the parents have maintained since birth. The amount in that savings account, for example, may also be considered. So I mentioned the standard of living is important for the spouse, and that we should not take for granted that the standard of living will be duplicated. For children, the court does try as best as practical to make sure that the standard of living for the child will not be significantly affected. So the court should consider, and when making financial provisions, that the child will be able to live a similar lifestyle as prior to the breakdown of the marriage. And also the court sometimes may consider in terms of determining how much the husband or wife should get, is that they don't want the child to go from the father's house to the mother's house and have to experience a huge discrepancy in terms of what they enjoy in their respective parents' place. And this is especially important when there's an access of stay in either spouse's homes. So we move on to the sharing principle, and if we talk about the sharing principle, we have to discuss the case of LKW versus DD, which changed the landscape quite a bit over the last 10 years. In that case, in short, it provides 4 guidelines and 5 steps as to how the Section 7 factors are considered. In most cases, available assets will not be sufficient to cover both parties' needs. So the latter steps in LKW versus DD may not be as relevant. So this case may be more relevant for parties where there's surplus assets to be distributed after having considered the needs. I won't go into too much detail, but I will summarize the 4 guidelines and also the 5 steps, and then we can take into consideration how that can be applied in real life when Alfred later talks about the case. So the first guideline is the objective of fairness. It's important that the distribution of assets will be fair between the parties. And in that case, the court rejected C versus C, which restricted contributions primarily to financial contributions and also reasonable requirements. So it was held that just allowing financial contributions and reasonable requirements to be considered is not fair. And this goes into the concept of discrimination as well, because in many cases, for example, the wife would have contributed non-financially, but the husband would have contributed financially. And we should not discriminate or have any gender discrimination in terms of the financial contributions between the parties. And the yardstick of equality, which later develops into the sharing principle, is that the rule is that equality should not be departed from unless there's good reason to do so. Now, that is the general principle, but in reality, having looked at all the circumstances, most of the time, one party will receive a bigger share than the other. And the last guideline is the rejection of minute retrospective investigation. So basically, in many cases, the court does try to encourage settlement, and they will not go into the minute investigations of a certain amount or a certain act that each party has done as to discourage settlement. So that's also something that the courts will take into consideration. Now I will go into the 5 steps to discuss how the distribution and the exercise that the court will go through in determining the assets that are distributed. So the first step is to identify the assets. At this stage, there's no distinction between matrimonial assets and non-matrimonial assets. The court will primarily just look at the assets that each party has, whether they're matrimonial or not. And Section 7 factors will come into play. For example, the income and earning capacity or property or financial resources that each party's had will be relevant. Step 2, it will be assessing the party's financial needs. As I mentioned earlier, many cases may not go past step 2 because there may not be sufficient amounts left over after having considered each party's needs. In that case, the Section 7 exercise will stop at this point. But in general, the court will not go into every single decimal as to how much needs will be required, and they would just generally interpret and take an approach of what the parties will need instead of just perceiving it at the lowest common denominator. And as I mentioned earlier, at this point, the court should consider that the children should enjoy a similar standard of living as during the marriage. The third is for the court to decide where there's surplus left over, whether the sharing principle will apply. And as I mentioned earlier, it should only be departed from if there's good reason to do so. Now, in reality, there will be a lot of factors that will be relevant as to providing a good reason to depart from the sharing principle. But what weight to be given on certain factors the court will have to consider. And just because one of the factors may be engaged, it will not automatically mean that the sharing principle should not be applied. So some of the examples and factors that the court may consider, for example, would be the sources of the assets. So this is where it comes into play things such as inheritance or gifts, or whether the property or the assets were acquired prior or after the marriage. There's also whether the assets were derived from one spouse through an investment conducted solely by that party. In that case, it was called unilateral assets, but it did also mention that as the marriage gets longer, it would be a lot more difficult to determine what is family assets and what are unilateral assets. And as I mentioned, because of the importance of the sources may diminish over time as the duration of the marriage continues. Another factor that the court may consider is the conduct of the parties. Conduct is quite specific and the threshold is quite high. It would only be relevant if it is obvious and gross. Now, this is not a layman's term of obvious and gross in a sense that, oh, she has a mistress, so that's gross. It's not really like that. So examples of where conduct would be obvious and gross for the context of application would be, for example, if a wife assisted the husband with suicide in hopes of taking the assets so that she could set up home with another man, or a wife hiring a killer to murder her husband, or whether there's wanton dissipation of assets. Examples where conduct will not be obvious and gross would be, for example, if even if the husband has a mistress or a wife had a child with another man, these may not meet the threshold for what is obvious and gross for this context. Of course, even as to whether the sharing principle would be departed from, the court will consider again the needs of the party, duration of the marriage, as well as contributions to the welfare of the family. In contributions in the sense to justify a departure from sharing principle, it would have to be stellar or special contributions. So this threshold, once again, is very, very high, and it will only be considered in exceptional circumstances. Compensation, which is, we go back to the Section 7(1)(g) factor about losing a certain benefit because of dissolution of the marriage or loss of chance. Compensation and financial needs would include, for example, things such as pension. Now, in reality, the courts, it will be an exceptional case that a separate element, and this will be regarded as a separate factor to consider, because in reality, when taking into consideration all the circumstances and the contributions and whatnot for each party, there will be some sort of overlap between compensation and all the other factors, such as needs or contributions. So the courts will try not to award more just because a party has lost the benefit of a pension, but this is just a factor to take into consideration. The weight to be put on may be a little bit less compared to all the other Section 7 factors. And if a compensation is found suitable to be awarded, generally the court will just take a broad brush approach to it. And the last step, obviously, is having taken into consideration everything, the court will step back and make sure that everything is fair, everything is not discriminated, and all the parties' needs are met, and in determining the final outcome. So this is the few steps that the parties, the court will go through in determining how the assets will be distributed and what share is suitable in special circumstances, in these specific circumstances. Perhaps in our next section, Alfred can guide us through a case study that we came up with to see how everything that we have talked about today can come into play.
It's actually more like me asking you for assistance. Perhaps we can go to the next slide to understand what my situation is. For this case, I am Andrew.
Hi, Andrew.
Hi. Tracy, I want to get a divorce. Let me tell you a little bit more about my situation, okay? I'm married to Betty, and we married in 2005, so it's around 16 years already. We have two children, Cindy and Denis. They're only 9 years old and 6 years old. I'm a banker. I make around $15 million a year. I think it's not a lot, but it's okay lah, huh? So because of my income, Betty doesn't, my wife doesn't have to work anymore, and she's minding the two children, doing the housewife thing, like taking them to school, taking them to ballet lesson, taking them to all these lessons. I actually don't understand what they're doing, but then I don't care. We live in a home, and it's now around $14 million, but there's a $20 million of mortgage in it. And I also have my account, which is with my private banker. But that is something that my wife doesn't know. She only cares about the children. She never pays attention to me, so she doesn't know. It's not that she doesn't have any money, huh? She has inherited a small flat from her father. That is before she got married to me. And she's receiving $10,000 as the rental income. The value is around $10 million. So she spent around $25,000, and the children's the school fees and the training and all this is around $40,000 a month. What happened is that she just found out that I have a girlfriend, and I just moved to the hotel last night. After a big fight, she really confronted me. She was streaming up and down and saying she wanted a divorce. She doesn't want to live with me anymore. So she was erratic, and I tracked myself into a hotel. Now I'm scared. I'm scared of a divorce. What if she petitioned to divorce me? What will I lose?
Well, I think the first thing is if she petitions to divorce, whether you would contest with a divorce. But assuming you are not against the idea of the divorce, then the next issue would be any financial obligations that you may
It
have.
very much depends on how much you will be asking for. But the first question is, should I just stop paying maintenance? Just stop paying maintenance so that she cannot come after me.
Well, even if you stop, she can still go after you, just through the court system.
At least she cannot hire a lawyer, no? Lawyers I understand lawyers very expensive these days, so they cannot hire a lawyer. She cannot hire a lawyer, she cannot go after me.
Well, she does have $20,000 that she obtains every month from rent, no?
Yeah, 20,000 is peanuts. Lawyers, I was told it's very expensive. Yeah. Yeah.
Well, I do think she would still be able to get some help and get some.
But she cannot. She cannot ask me to pay for her lawyers, right?
Well, through the course she can.
Really?
Yes. Well,
But-
I think.
But if I am paying for her lawyer to go after me, isn't it very unfair to me?
How would I frame this?
That's why
Well,
the
that's
court
why-
sets up a higher threshold test.
Yes.
So that if you pass the higher threshold test, then it is fair for you to. I mean, it is sometimes in rather nasty language described as paying someone to buy a knife to stab you with. So yes, there are situations where you will be asked to pay someone to pay for the very weapon that then attacks you. Yes.
So so I cannot really just stop her, get her dry, so that she cannot go after me. How about if I stop paying for the children's school fees? Well, can she go after me for the school fees?
Well, yes, because I think the children have been supported by you all along, and you will not be able to, just because you don't stop paying the children fees, and then you can run away from your obligations as a parent.
Okay, but then can I claim that I have no income? I just quit my job.
Well, there is full and frank disclosure under the Form E, so you can't claim that you have no assets.
But then if I don't disclose my assets, my banker's account, she wouldn't be able to know. How can she trace?
Well, there is the full and frank disclosure, right? So.
And she cannot go after me with going through my Form E, going through my bank accounts and find out whether I have money in hidden, right?
Well, there are also questionnaires which the wife can raise pertaining to
What's a
your
questionnaire? Sorry, now you make me scared.
Well, questionnaires are basically, as the name suggests, questions pertaining to your financial disclosure. For example, the Form E usually requires 12 months worth of bank statements, and the wife may instruct the solicitors to get bank statements beyond 12 years. And also ask for your credit card statements, which will also show, for example, your hotel expenses with your girlfriend. And, and there will be detailed investigation as to your lifestyle, the spendings, the withdrawals, the incomings to your bank accounts. It will be a very draining exercise for you as well.
I think one thing to point out at this juncture is the Form E represents very much a basic minimum. It is absolutely a basic minimum. The Form E is designed to be the lowest common denominator. It applies to every single person going through the court system, whether you earn $5,000 a month or you earn $500,000 or $1 million a month. It doesn't matter. You still start with the same Form E. Now, after that, it becomes a case-by-case matter because typically, in most cases where you would have a team of lawyers involved, say including a barrister, which is where I would come in, that's in typical cases like that, you do not just live with the Form E disclosure. For example, investment accounts, the Form E asks for, I believe, the latest statements.
Yes.
Now, if you have an investment account with 30 million in it, of course, nobody will be satisfied with only the latest statements. Credit cards, I think the Form E only asks for 3 months. If you want to see spending pattern and the family puts most of the expenses on a credit card, you want the last 2 or 3 years. It's actually quite typical in larger cases to be asking for 3 years, which of course also ties in with a potential statutory presumption under Section 17, which is also 3 years. So that's one of the many reasons why typically when it comes to the questionnaire and answer stage, very few cases involving a team of lawyers would actually be one where you just give the Form E disclosure and stop. Usually there would be questionnaires. A questionnaire to a normal civil practitioner, the easiest way to understand it is that it's a mixture of specific discovery and interrogatories. So you're not limited to asking only for documents. You're also allowed to ask questions for information and explanations and answers. In the context of civil litigation, that would be an interrogatory, which usually happens after witness statements. But in divorce cases, you can administer what are in effect specific discovery plus interrogatories after Form Es are exchanged.
But it sounds like it's so how do you call it? I have no privacy anymore. It's like in the divorce proceeding, I get to disclose everything in the course of the marriage. It's very intrusive, isn't it?
Well, everything that is relevant to the determination of the matter, so not necessarily everything.
But what if my wife claims that she's spending like $50,000 a month instead of the 25 that she's always been spending? Can I contest it?
Yes.
Inflating. I was told that she got advice from her girlfriends that she can easily inflate her expenditure every month. Like she didn't used to go to the hair salon and perm her hair every month and doing her nails. You know, can I contest it?
Yes, and I think this is where Jeremy, when he mentioned spending patterns, it's going to be taken into consideration whether you have been spending $25,000 a month for the last 10 years, and then suddenly after divorce you're spending twice that much, and clearly that would show that you have been inflating your expenses. This is one of the factors that the court will take into consideration, and you can show that.
And what Tracy said actually often happens in real life.
Yeah.
You often do have friends who say, oh, if you want to pump up your needs claim, you might as well spend more. It's always a bad move because you always have full and frank disclosure. You have all the statements and financial records disclosed. And what will happen is your opponent will plot a graph that will show a line which suddenly jumps up. And that's very embarrassing. So.
Oh, okay. So she cannot inflate her expenses in that case. But how much should we be asking from me in terms of divorce? In terms of overall?
Well, I think in terms of, for example, periodical payments, the court will consider how much she has been spending prior to the breakdown of the marriage. So in this case, if it's $25,000, then this would be a need consideration for the needs that the court will consider.
But how about the home that we're currently living in? Would she be asking for it as well?
Well, I think in reality, if the kids are going to be living with her, then the courts will take into consideration what to do with the matrimonial property. If the kids will be living with her and she has been living in the matrimonial home, then it's likely depending on, because I believe the court will take into consideration the whole pot.
Yeah.
So it's not so much that you give her the home and then possibly you give her the home, but then you get some more of the cash, rather than you just give her the home and you're left with nothing at all.
But then it's $40 million. Why should she get a $40 million home? She can certainly live in a smaller place if we are separated.
Well, I think it would depend on all the assets of you and Betty. But I think one important factor is that the court will consider where the child has been living prior to the divorce. So prior to the divorce, if they've been living in the matrimonial home that is a certain size and a certain location and they go to school there, the court will definitely take that into consideration and hope to make the divorce affect the children as least as possible.
Oh, okay. Okay. Let's say I'm giving her the home. Should I be getting away with with nothing? Is that all? I could just give her the home. Can I keep my $20 million with my bank? But I have a $20 million portfolio with my bank. Can I keep the? Do I just give her the home? Would it be fair? It sounds very fair to me.
Well,
Well, the whole pot is only 40 million. No, she also have her apartment from her father. It is stuff like
10 million.
10 million.
Yeah.
So her 10 million plus the $20 million home plus 20 million is 50 million. Well, this is all we have. So I give her the $20 million home. She has the 10. I only keep 20. It sounds very fair to me.
Well, maybe Raphael and Jeremy can weigh in here. Would the inherited property be taken out of the matrimonial pot if it was prior?
Yeah, I think there are Andrew and Betty here are faced with, of course, all facts are different, every family is different, but there are actually some pretty salient features of this particular family. Andrew is an extremely high earning person, 15 million, that's over $1 million a month. However, they do not appear to have saved very much because he is only worth, on the face of it here, 40 million. 40 for a home minus a mortgage. Notice that the mortgage is higher than the amount paid for initially, so it must have been a later mortgage, remortgage or second mortgage. One wonders what happened to that money. Perhaps it's to be found in the private bank accounts. In total, that's 40 million, which means he has less than 3 years of earnings saved up. I'd be quite interested to know whether his 15 million is a recent increase or whether it's been going on for a while. Because if it's been going on for a while, then they should be spending a lot. Yet when one turns to the spending pattern, we see that she only spends in the region of 25,000 a month, 40,000 for a child, which means on a needs basis, it'll be a very modest Duxbury calculation and a very modest needs claim, and it may well be one where the court says, 50-50 sharing deals with everything. However, the home itself is worth the entire pot. So it's a toss-up between, do I go with sharing, or do I give the child the home the child has always been used to? But that's 100% of the pots. Now, I think in a settlement scenario, a fair outcome might be that there's a approximate 50-50 division with the wife having the entire home, but some arrangement is made for the payment of the mortgage so that the wife and child can carry on having the home, and yet the wife isn't being given the entire pot. So some arrangement has to be made. She will probably end up getting, in some notional figure term, more than 50, but perhaps she takes over most of the mortgage, or perhaps the husband helps out on children maintenance. The husband, of course, would pay for children maintenance, earning the amount that he does, but perhaps some elements of that could be going towards the mortgage because the child is living there too. So I think that would be the complexity I see in this case. It's neither a straightforward sharing because the home far exceeds that, which, given the assets and income, they just don't really match up. It's especially with the low monthly expenses. But on the other hand, to give her the home outright with the child would wipe out the entire pot. So it's actually, this factual matrix gives rise to quite a difficult case, which would ideally be settled by an arrangement which no court could order. The court can't order the transfer of property together with a mortgage, for example. In fact, your mortgage bank would not, the bank would not even allow that. So you'd have to run into all sorts of problems if it went through the court system. But on a settlement, we can be a lot more creative and sort of come up with a different arrangement which could achieve fairness for everyone.
Well, I see it differently because based on the facts of this case, if he's earning 15 mil per year, and if the case lasts for 2 years, then that is 30 mil. It's more than enough.
Unless he spent the rest of it. Maybe she spent very little, but he spent the rest of it.
1 mil per
I'm
month.
very good at controlling her expenses as the wife. As the Chinese people always say, don't let the wife feed fully.
Until she's like 60 or something.
Correct.
40.
Oh, 40.
Okay. But children nowadays very expensive, and clearly in this case, in my scenario as Andrew, it seems like I will have to continue paying for the maintenance of the family until the case is resolved. Would if she would be asking me for a maintenance, would she be asking me for a periodic payment, or should be asking me for a lump sum?
I think for the children, definitely periodical. I think for the spouse in this case, probably periodical as well.
Children maintenance is always
Yes.
periodical, and lump sum doesn't apply. In Hong Kong, I believe as far as I'm aware, there are very few judgments involving lump sum for a child, and it's always by agreement. And so it's only because the parties agree. For example, a father who's not very interested in taking part in the child's life might say, "Well, I'll give you a certain amount," and you can calculate it. It's more than enough. It'll definitely see the child through all the education until beyond university. If the judge is satisfied that that sum will definitely be enough, I mean, what sum is enough is, of course, a sort of, there's a window of it. But if you go far beyond that, which the cases I'm referring to do, go far beyond any reasonable amount which a child might need, then the judge might approve that, even though it's a lump sum, and even though it appears to be not variable over time. Of course, there's always the fallback, which is that if the child has maintenance needs and the money runs out, something drastic happens, you can go back to court. You cannot oust the jurisdiction of the court on children matters. In fact, you also cannot reach agreement on children matters to bind each other without the court's approval or sanction. So insofar as children are concerned, the court's jurisdiction is preserved and remains far more flexible. But it's usually dealt with by maintenance, which is variable.
But if she be asking for a lump sum, would she be asking for more than half of the family pot? The family pot is only 15 million. And she's only 39 years old, if I remember correctly.
36.
Yeah, I forgot her birthday. Yeah, because Duxbury, when you're calculating for the rest of their life, she may have 40 years of lifespan, and she would be if you're asking for a lump sum, then it could cost like millions and millions of dollars. Would it be possible?
Yes, I think age is a major factor here. One of the ironic things about a Duxbury is that the younger you are, the more you get, but the younger you are, the shorter the marriage would have been. And the older you are, the less you get because you have less life left in you. But the older you are, generally, the longer the marriage would have been. So it's sort of a reverse logic. It also doesn't really work. It's more theoretical than real because on the Duxbury calculation, they use statistical data for lifespan. And it's calculated so that when you die, you have just consumed your last glass of champagne, as some of the cases say. So you've lived a luxurious life. You're spending $500,000 a month. And in your final month of life, you will spend your last $500,000 and then you pass away. Of course, that doesn't happen in real life. So inevitably, you will have to do some financial planning. The Duxbury is a calculation really more theoretical than real, which the courts then use as a guideline. Another, of course, ironic feature is the more generous you are to your spouse, the worse off you are when it comes to the Duxbury calculation. The more miserly you are, the better off you are when it comes to the Duxbury calculation. So that's another sort of point of unfairness. So there are many reasons why the Duxbury is not the be-all, end-all, and many reasons why the courts say it is a tool, not a rule, as Tracy highlighted. Of course, where you're dealing with a young spouse, as here, who spends very little compared to the earnings of the husband, it may well be a case where actually some sort of sharing arrangement or some sort of capital arrangement could actually absorb the entire Duxbury calculation. Yeah.
But she used to be a teacher. She can go back to work so that she doesn't have to pay, she doesn't have to rely on me.
Yeah.
Isn't it fair after divorce that she go back to work, especially when the children become older, Would the court order her to go back to work? I only want to save as much as possible in terms of maintenance.
Yes. I think the answer is that a 39-year-old with with children 9 and 6, there are no special facts in particular. A court would probably expect her to go back to work once the younger child has reached, maybe some way through primary school.
So the court's attitude is that they do not encourage people to just stay home and not work, right? No, but I mean, it's a matter of earning capacity. It's a matter of earning capacity. Let's say if the situation changed a little bit, instead of, I'm sorry, next slide, please. Oh, that's all? Yeah.
No, that one.
No,
Next slide.
Next slide. Yeah. So the situation now is a little bit more different. We're talking about I'm 59 years old instead of 39, and Betty is 26. That means that I was I'm marrying someone much younger than me, and I have a business. Instead of being employed as a banker. And I'm much more loaded than 20 million. Like earlier, we said that the case is a bit the middle class that probably not worth a sharing principle. And she inherited the flat after she got married. I think the first feature is that would relatively short marriage. Is this a short marriage? I'm 15, 16 years of age.
Well, if she was 26 here, then
Oh, sorry.
I assume they wouldn't have been married for 15 years.
Indeed, yeah. So it would be a shorter marriage.
Shorter marriage. Yeah.
It would be a shorter marriage. Would the 200 million be compromised or shared?
I think if it's a shorter marriage, I think the fact that Betty would be 26, it would affect her earning capacity because she would have, obviously, it would be easier for her to go back to work compared to when she's 36. And also because it's a shorter marriage, then there would be, as mentioned earlier, there would be less for the parties to call up on in a shorter marriage. So if it's a marriage of, for example, like I assume 5-6 years at most, then it would be easier to draw a line in terms of what assets should be shared and what not.
And associated with what Tracy is saying, it also depends upon how and when that 200 million was accumulated. Because if it was all accumulated, I mean, they couldn't have been married more than 8 years, for example, 18 to 26. But if the whole of the 200 million was actually earned and accumulated during that 8-year period, then it should all be matrimonial and it should be split. And if it's 100 million each, with the spending pattern we saw earlier, then needs would certainly be covered, and it wouldn't really be relevant whether Betty works or not. That's up to her if she's worth 100 million. But if he's 59, and in fact the 200 million was always there even before marriage anyway. So 8 years ago he was already over 50, and he says, actually, I'm worth less now than I am when we married. My business has suffered during the marriage. That gives rise to a much more difficult situation. And there's a case in Hong Kong, PPTW, which deals with approximately that sort of argument where an older gentleman marries a younger woman, and he says, well, by the time I got divorced, I'm actually poorer than when we married 10 years ago. What happens? Well, of course, it depends on the case. In that case, there was a lot of mixing and mingling, and the wife ended up with 45%. That 10% difference between 45 and 55 was in recognition of the fact that before marriage, the husband did have a certain amount. And being a business owner brings in its own difficulties, because whenever you're talking about a private business, a private company, you don't have an open market in the sense of the stock market to tell you what it's worth. And valuing a private business is perhaps one of the most controversial exercises involved in divorce litigation. There is a process which is akin to the kind of valuations that an M&A or an IPO might go through, except that the court looks at it and scrutinizes it far more stringently than the SFC does. So the court will be looking at a valuation of a private company very much from the point of view of a buyer or a seller on the open market, rather than SFC, who they make sure that everything is proper and investors are being protected, minority shareholders are being protected. But I'm not sure that they run through the same sort of level of detail and possibly cross-examination of experts that a court goes through when valuing a private business. So that's actually one of the most complicated aspects in terms of varying the facts and changing the case completely from a employee case to a business owner case.
Yes, I do remember that many years ago we did have a case that you were on the other side, and the business owner own company, which is if I remember correctly, is trading company, and I think the company's service were evaluated professionally as around like 200 million. Comparing the business with some of the similar businesses of a listed company, I remember. The overall matrimonial post is around 500 million, if I remember correctly, and the business itself is on 200 million. So in order for the husband to keep the business, he has to pay around because around half of a long marriage with children that has already been grown up. The overall assets is 500 million, so it's around 250 million mark. Because of that, basically the husband's own assets is wiped out because most of the assets are tied, the 200 million is tied with the company that he never considers worth that much. And I think this is one of the major problems that is presented with the entrepreneur who has their own business and at the end of the day ended up paying more than what they have envisaged at the beginning when they're going through divorce.
Yes, in fact, it's a very difficult problem to resolve because when times are good, when the market is doing well, and PE ratios are at all-time highs, a lot of business owners find that on paper, in valuation terms, they are worth a lot more than they thought they were worth. And they find that their liquidity, like an investment portfolio, is actually worth considerably less than their business. So how do you divide the assets so that the wife can exit the marriage? And yes, I don't have to sell my business because, and a court may well take the view, for example, well, you are worth that much because your business is worth that much. And the valuation is performed on the basis that you can sell it. So if you choose to keep it and pay your wife, well, you're going to have to solve that problem. But what you should be doing is selling the business and paying your wife. Now, of course, there are other options. You could pay by installments. The court won't give you an indefinite amount of time. By arrangement, you could agree to something lesser. The wife might agree to be a minority shareholder. Unusual, but she might. I've seen that before. We have had cases where neither party was willing to let go of the family business, and they actually agreed to divorce, but agreed to remain partners and set out something akin to a joint venture agreement or a partnership agreement going forward. Those are possible solutions. Another solution is perhaps to talk about period over time, selling the business. We have to come up with basically creative solution. The court system has very limited powers. The court can either order transfer of shares over to her, or you simply order a lump sum and you have to deal with selling the business. Now, something to bear in mind is the concept of financial muscle, equal financial muscle, because sharing, equality, sharing principle, we often think that we are dealing with figures. And in terms of valuations, Form E, schedule of assets, you are looking at figures. But there is a difference between $100 in the bank and a business that is worth $100, which you could sell, but do you really have have a ready buyer for it? That illiquidity, part of it will be reflected in terms of the valuations, because a lot of valuers will factor in something for lack of marketability, a discount for being a private company. But the court itself will also take that into account, that the two parties are exiting the marriage with different figures, but also assets of a very different nature. So a court might think, for example, that a wife exiting the marriage with $80 in the bank is actually in the position of similar financial muscle to a husband who has a business worth $100 million. Because to turn the $100 million business, $100 business into cash, well, immediately, you might have to take a discount for that if you want it immediately sold, like a fire sale. But on the other hand, if you're going to sit on it and earn with it, then you're taking a business risk, and there's illiquidity involved. So when one takes that into account, equality doesn't necessarily lead to equal in terms of digits or figures. It's equality in terms of financial muscle.
And a lot of time, business owners do have this grievance. They think that this is not fair to value the business based on selling it, because as soon as the business is sold, they're not there anymore. They are the heart and soul of the business. They run the business. They have the know-how. They have the contact, and it's effectively like evaluating his own contact.
Yes. That's more a question for expert evidence, but accountants, experts do take into account something called the key person discount. So where there's a key person discount, where you cannot, for example, just a barrister could have a service company, or a dentist could have a service company, a doctor could have a service company. That service company is not something you can sell. You can't sell a dental practice without the dentist, right? Or you can't sell a medical practice without the doctor.
Yes,
unless, of course, you're a big clinic with a lot of doctors, so you're selling a brand, you're selling a reputation.
Yeah.
But a solo barrister with a service company, well, you can't sell that company. It has to come with the service provider, the professional. In those situations, an expert would probably factor in a key man discount. Because in real life, if you were to enter into such a sale, there would be restrictive covenants, there will be restrictive trade clauses, and you would have to carry on, probably promise to carry on, and possibly have certain targets to meet for the first few years. Of course, the court will not value on that basis. The court cannot value a business on the basis that the key person will go with the buyer and will promise to perform at a certain level for the next 3 years. A court would not ask for that. So the open market value that a court assesses would be an open market value with no strings attached, not an open market value with you binding yourself to carry on a certain way. Yeah.
Yeah. Another thing that is very often happen is inheritance. Especially those inheritance that are received in the course of the marriage, like this case study scenario. Would it fall within part of the matrimonial pot?
Well, LKWDD would tell us that you always value the entire pot. Assets inherited would maybe considered dynastic. They would start life as non-matrimonial assets in the sense that it comes from a source external to the marriage. Over the course of the marriage, that nature can change. It depends on what you do. If you leave inherited assets aside and really don't do very much with it, it's left to one side. Like in the case of K&L was a case where the pot was worth, I think, 50 or 60 million pounds. It's in tens of millions of pounds. And I believe the award in the end was somewhere in the region of 5 million pounds. So less than 10%. But of course, it wasn't a case calculated on percentage. It was a case where the pot was considered non-matrimonial in nature, and the husband was awarded a needs award. So 5 million pounds was a needs-based award. But on the other hand, if during the course of a marriage you completely mix and intermingle, and the inherited properties become very much part of the matrimonial life. For example, you inherit a house and you live in it together as a family. Well, then that's pretty hard to escape a very high amount, very almost equal form of sharing, where you have yourself brought in. I mean, sometimes the expression that's used is intention to share. If you live in a home together and that home's inherited or maybe paid for by your father, you are demonstrating an intention to share by living in it together.
I think this kind of highlights the importance of couples like this having a prenup before the marriage, in order not to intermingle those assets out before marriage or inherited in the course of the marriage. But a lot of time, actually, it is a very sensitive topic that a lot of people do not want to talk about. Marriage is supposed to be romantic. And when we talk about the prenup, actually, it destroys the whole scenario. So at the time when we have come across a lot of questions like this, how to approach to this question, prenup. And nowadays, people a lot of time use the excuse of parents, for example. Parents would demand the couples to sign prenup before getting married, just to protect the family wealth from the being eroded in the course of real divorce claim. But of course, I always say that prenup, it is itself a relatively new concept in Hong Kong, with the adoption of the English principle that there are certain criteria being met, including asset disclosure, separate legal representation, agreement to be made in the way before the marriage, and ultimately, not only the agreement has to be fair, but also the agreement is only of persuasive value. So I believe that it is an effective tool, but sometimes not a very effective tool. It very much depends on the circumstances. And this is more and more people would be talking about. I think it is about time that we let people talk about, ask questions. We have a lot of questions, actually.
I think we actually need to have the law society question. Right? Yes, we need to. Now, everyone who wants their CPD points, the question must be answered. I don't think it requires a correct answer, but it's the clicking of the answer that demonstrates you're not away from the computer doing something else whilst leaving it on, but are actually here at the moment. So a question has come up, and amazingly fast answers. Perhaps we can read out the questions. A mother has no freestanding claim under GMO. True or false? Remember that the statute is called the Guardianship of Minors Ordinance. Can legal cost provision be considered as reasonable needs? And thirdly, are clean break provisions applicable to children?
3 questions? I think we have more.
There's more.
Yeah.
Okay. Does the sharing principle apply to all marriages? I might consider that a trick question. Because it's sort of, yes, but not really.
Principle
Yes,
itself.
The principle is applicable to all
itself
marriages, but it may
applies.
not apply in the same way. So, can you backdate an NPS application?
There's questions online, so maybe I can read the first one out. Jeremy, can the court provide for capital needs of the minor child by way of maintenance needs?
Okay. Depends on what is meant by capital needs. In terms of can the court award something which is in nature of purchasing a capital item because of the needs of the child? Yes. I mean, a car is a typical example. A car might be worth, so you get an Alfred or an Elgrand, a Tesla, typical car with a driver for a child. Those would be that can be provided for a child, even though that is an element of capital. And in fact, the GMO itself allows for a provision of capital, although it won't be capital on an ongoing basis. You tend not to, for example, see a case where the court says you shall buy a property and give it to the child. But the courts do make orders where they say you shall buy a property and let the child live in it until the child finishes university. Now that is an order that can be made under the GMO. That is a form of capital provision, but the child doesn't get the capital. It's an accommodation that is provided for. So it depends on what you mean, but the answer is yes, the statute allows for it, but it tends not to be for a capital asset like a home. It tends more to be something like a car or a debenture, something like that, which is really directly for the child, but it happens to be a piece of capital.
And then we have
Next question says, are the son, which is over 18, and his children, grandchildren of the deceased, who's been receiving periodical payments from the deceased for living and educational expenses qualified for a claim?
I believe that it is something in relation to the IPFDO, the 481.
Yes.
Yeah.
And if he has always been a dependent, theoretically, yes, but then if he's an adult child, then he has to satisfy that at the time when the deceased passed away, he has been financially maintained, he or she has been financially maintained by the deceased. So it will be on a need base, and the same applies to grandchildren, because IPFDO is actually a very wide section. Basically applies to all people that have been financially dependent on the deceased. So I guess the answer is yes.
Yes.
And also what happened to the assets of the deceased during the proceeding? Will it be frozen until the case is finished? It's a very interesting question. The problem is that if the claim was raised after the grant is being issued, Jeremy has mentioned that there's a 6 months limitation period. Theoretically, the administrator of the estate can still administer the estate by calling in all the assets and hold it until the case is finished. Of course, by that it means that it's not frozen. But if the case was commenced before the grant was issued, then very much depends on whether the claimant will have any issue with the grant being issued to the person who is entitled to the grant. And without a grant being issued, of course, the assets will be frozen, and because nobody is able to administer the estate. And that could be a topic that can go on forever and another session.
I think everyone who sort of needs to answer the poll question seems to have answered it by now. Thank you very much, everybody, for today. It's been an amazing turnout. You cannot see each other, but we can see the number of participants here, and it's been an amazing turnout. Yes, I think it may be a matter of misreading the answer, because the mother has no freestanding claim under GMO, true or false. It's not yes or no. The answer is no, and it is false. Sorry, it is true. See, I got it wrong. It is true, because the question has no freestanding right, so it's true. But if you were thinking yes or no, which the rest, I can see the confusion, because the rest of them are in the format of yes, no. So yes.
So it's another tricky question.
I suppose it is.
Yeah.
Can legal cost provision considered as reasonable needs? In fact, before all these cases started calling it Curry and legal cost provision, in fact, the whole concept of Curry and legal cost provision stemmed from an expansion of the concept of needs, because the jurisdiction for legal cost provision is actually the very provision that gives rise to maintenance. So it's Section 3 in divorce cases, and it's Section 13 in GMO cases. Those are the sections that give rise to the ability of the court to award legal cost provision. So inherently, it stems from needs. In fact, fundamentally, one might say the requirement to have to pay lawyers to fight the case for me is not so different from, for example, the fact that I need to have a surgery and therefore need something to pay my doctors with. There is a need for me to hire lawyers or a doctor or driver or maid. These are all people who I need in order to provide for my life going forward. In the case of legal cost provision, my litigation. It is not something I can escape from, which is also why the question of reasonableness does come into play, because if the applicant litigates unreasonably, the court looks at it and says, well, yes, I can see that you need to hire lawyers and you need to fight this divorce case or this GMO case, but the way you're doing it is not very reasonable. You seem to be going overboard. You don't need a legal team that big, or you don't need to be taking out so many applications, or your questionnaires are going a bit overboard. Not only may you lose the application and of course awarded against you, a court is unlikely to provide legal costs by way of Curry orders in those situations, because whilst your opponent is obliged to, once the Curry provisions are satisfied, is obliged to fund your litigation, they do not have to fund unreasonable litigation. The legal cost provision, jurisdictionally, it must be by way of periodical payment. It must be by way of monthly amount, because it falls within Section 3 or Section 10, but both of those are dealing with monthly maintenance provisions. So jurisdictionally, it cannot be a lump sum. But the reason why I say jurisdictionally, because in practice, in reality, it is never calculated in that way. In reality, it is calculated by way of a budget. So the court says, if I look at today, what bills are outstanding and what fees are likely to be incurred until the FDR, you usually come up with a number. And that number is then divided by the number of months between now and the FDR. And the court would, for example, if the court says, I think to take this case to FDR will cost about $1 million, and the FDR is probably about 10 months away, so you will pay $100,000 for 10 months. It's phrased as a periodical payments for a limited term, because the jurisdiction requires that we must do that. But in reality, it's actually calculated as an overall budget and then divided up by the number of months.
Should we answer some of the rest of the questions?
So the next question is how to consider the fair distribution when the wife is working while the husband resigned 1 year ago by his own record. The man has no intention to look for jobs and borrowed money from the wife for stock trading and suffered losses. The wife therefore decides to divorce and they have a child. The husband has no further savings and the wife has some savings.
You know what? This is unfortunately quite common, especially when one party of the family suddenly lost a job and decided not to work anymore. And unfortunately, in a way, in the law, it's not gender biased. So just because if the wife has financial resources to pay and the husband has the need, theoretically, the husband can still make a claim if he claims that he has been a dependent. But in reality, I find a lot of husbands not very willing to make such a claim. So a lot of actually in our cases, we come across a lot of husbands may threaten to make such a claim, but at the end, whether to make such a claim or not, and it very much depends on how shameless the husband is. I'm again being gender biased. I don't know if Jeremy, you have anything.
Yeah, there's also the court under Section 7 looks not only at income but also earning capacity. So when the question says the husband resigned of his own accord, the court may well say, well, I don't really care whether you choose to go out and work or whether you, for example, you might suddenly quit your iBanking job of $15 million a year and decide to go and study some program which necessarily leads to a low-paying job by way of a new degree or PhD or something. You can choose to do that. The court will still take into earning capacity. Earning capacity is not the same as your income. Your capacity could be much higher than your income. It tends not to be lower. In some situations, you do find that a person has a lower earning capacity than his income during the marriage. That typically applies to situations where somebody marries into a bigger, wealthier family and is given a position paying a salary which otherwise in the open market he could not obtain. Now, in those situations, you may well find that upon exiting the marriage, one spouse or other is left in a position where his or her earning capacity is in fact lower than the income historically he has been earning or she has been earning during the course of the marriage. So both are possible. Earning capacity can be higher than income, and income can be higher than earning capacity. Those two things are not the same, and the court has to take both into account.
And a lot of time, of course, when a person is claiming that he cannot find a job, he has the burden to prove it. And the court would certainly look into whether it is true that he cannot find a job. For example, now when the pilot cannot find a job, it might have more sympathy than after COVID, when the overall tourism industry start to grow. So it very much depends on the circumstances and whether the court would believe what the husband would say in that kind of circumstances, that he cannot find a job and so he has to rely on the wife.
And the sort of efforts that have been put into looking for a job, like approaching headhunter firms,
yes,
how many CVs you've sent out,
yes,
like that.
Absolutely,
and making adjustments. For example, the pilot example. For example, passenger pilots. A lot of passenger pilots are, sort of, their jobs are in jeopardy. But on the other hand, my understanding is that the logistics industry has been doing very well. Mm-hmm. So if you change from being a passenger pilot to being a cargo pilot, you might be perfectly fine. Maybe they're hiring a lot over there. So a court might expect you to make that sort of adjustments rather than saying there are no more passenger flights. I can't earn anything now. But the court might say, well, yes, but you're a qualified pilot. You can fly cargo. It may or may not earn more or less, but it's something you can do. So it depends on what efforts you have been making and whether a court can sensibly say you have really have made reasonable attempts to maximize your earning capacity.
One more follow-up question is that when one party has a large investment portfolio like stocks, futures, something like that, and in that case, does the party have the obligation to maintain the stability of the portfolio so that the value of the portfolio will not drop suddenly or substantially during the proceedings?
Depends on the historical norm of the family. If this were a speculative trader whose portfolio throughout the marriage had wildly fluctuated up and down, then the court might say, well, these few years we're going through a divorce. That's just a few years out of the 20 years of marriage, and the portfolio has always been fluctuating up and down. So that is very different from a situation where actually the portfolio has always been quite stable, and then suddenly, when it comes to a divorce, he or she is suddenly taking very big risks, and the portfolio is suddenly fluctuating very, very wildly. I think something like this will have to be taken care of by way of an injunction. I don't think there's there's some other way of catering for it. I think it's a matter of the the other spouse, not the one with the portfolio, the other spouse, looking at financial discovery and really being able to say somebody, the other side, is taking unreasonable risks with the family assets, right? If you can say that and be able to get an injunction to stop it, because if you can't get an injunction to stop it, then the cases would say, well, Hong Kong does not operate a system of sales conservatoire. So when you start a petition and you start running divorce proceedings, that doesn't freeze assets. What is one person's still remains that person's. You do not have a sort of equitable or beneficial claim to a share of the family assets. That's not how it is. You go to court and you ask for an award. And as part of that, the family assets are taken into account and weighed up, and the court has to decide how to distribute them. And in the course of doing so, before you get there, what is the husband's is still the husband's. What is the wife's is still the wife's. So it becomes a question of can you legitimately stop him from trading his portfolio in the meantime?
So the next question, it says, in ancillary relief proceedings, how is the value of the matrimonial home determined if it cannot be agreed between the parties? Also, what is the relevant time of determining the value of the matrimonial home, date of separation, or date of ancillary relief court order?
I think a lot of time, in reality, there are very helpful tools online, and like the mortgage, HSBC mortgage valuation tools that will help the parties into agreeing a certain value of the matrimonial home. Of course, it doesn't mean that all residential property in Hong Kong are valued by the HSBC or Hang Seng Bank valuation tools. Should that be the case, a lot of time the court would encourage the parties to try to agree over a valuation first. If it cannot be agreed, then a valuation report would likely be obtained. And who should be nominated as the valuer, it very much depends on whether, again, the parties can agree on the valuer. So in the divorce proceedings, the court actively encourage parties to try to agree directions as to how to proceed in dealing with any part of the matrimonial property, especially in terms of valuation. And when is it going to be reference? Where is the reference point? A lot of time that is at the time when the form year exchanged, and shortly afterwards, the directions will be made in relation to the valuation. It will not be at the time of the separation. It will be at the time when the ancillary relief claim is being dealt with by the court, because it's pretty much live. The court is dealing with a live issue, that is, what is the matrimonial home, how much it's worth. So the latest valuation will be taken into account. If the valuation is later on become outdated, the court can always order the parties to get an updated valuation.
We are talking about children payments, periodical payments, and that they generally don't come in lump sum form. But there was a recent case by Mostyn in the UK in the Court of Appeal, where on the variation application of one of the parents, he turned a periodical payment situation into a lump sum capital payment situation. Jeremy's nodding his head, so perhaps this case.
I'm aware of that.
And the reason for that was because there was a lot of animosity between the parties, and they had spent a disproportionate amount of money arguing. So one of the considerations of the judge in the lower court was that he wanted to bring an end to that, and ordering lump sum payments was a way to achieve it. So the question is very simple. Is that possible in Hong Kong?
Well, I think what Madeline has raised is actually a developing area, a very pioneering developing area, where English law has, I wouldn't say, it hadn't departed from Hong Kong in the way Hong Kong does it, but our statutes have over the last few decades become somewhat different. Hong Kong has barely changed our own statutes. Things like the Children's Bill have been left in hiatus for a decade or more, and we haven't really changed much to Cap 192. So one of the things that has been introduced into England is the concept of turning a periodical payment order into a capital. So after paying periodical payment for 10 years, a wife or husband might go back to court and say, okay, I really don't like this. You can afford it. Why don't you just pay me a lump sum? And to halfway through, after a divorce, halfway through a periodical payment order, to turn it into a lump sum order. Now, that is something that is quite routinely done, as I understand it now in England, because they're encouraging clean breaks. They're encouraging, even if you started off the divorce with a periodical payment order, to actually end it at some time in the future if it's financially achievable. Now, what Madeline has described just now is a case which is akin to placing that in terms of children maintenance. So say you start off with a children maintenance order, and there comes a point where you might say, okay, we don't really like this arrangement. Why don't we turn it into a lump sum order? Now, in England, perhaps it is the fact that in spousal maintenance cases, they now are allowed to do that, to turn a maintenance order into a lump sum order. That may have influenced Judge Mostyn to go in the direction of doing the same thing for children or something similar for children. In Hong Kong, we actually don't have that ability to begin with. So, for example, if the periodical payment order is made, that's a periodical payment order, and it will be there until the death or remarriage. Now, it could be a limited term periodical payment order, but that's a limited term periodical payment order, and that decision to limit it would be made at the time when the ancillary relief judgment is made. But we do not, in Hong Kong, have the ability to turn that ongoing PP order into a lump sum later on. That's one of the, we might say, statutory changes that have happened in England that we haven't adopted. So my view, is that for children, we do not have that available. But that's probably not because in principle we differ, but it's probably just because our statutes are actually different. I think the world is heading in the direction of clean break where possible, and I think judges in Hong Kong would love it if they had the ability to end periodical payment orders where possible and to replace it with lump sums. But we're not there yet. In fact, but there are actually more pressing statutes in family law which are awaiting legislation, reciprocal enforcement, children's bill, so yes, this is one of the things that we looked into in the future. But watch this space.
It seems like our time is running out, and I know that there are a lot of questions that a lot of people do want to ask, but it's unfortunate that we cannot answer all of them. But of course, you can always find a lawyer and ask all the questions, or you know where to find us. We're not going to do a lot of self-promotion, but I think today, we can wrap up here. And thank you very much for sharing with us all the family-related money issues. Family is a topic that requires a lot of discussion, and as Jeremy already just said, with the law requires some changes and updates, and perhaps we will have another opportunity to talk about it, especially if this is well received. Okay?
Thank you.
Thank you very much.
Thank you all very much. Thank you.